Good evening, everyone. Chip Cooper for FTC Guardian and my partner Alan Cutts. Here we are, the last hangout in the month of May 2019. And just a matter of personal interest here, we sort of decided we wanted to visit some friends of ours from Atlanta. So this past weekend, we went down south of here to the beach, which is part of the city of Jacksonville. It's called Jack's Beach, and had a great time. Great weather. We went out to dinner. We had a great time visiting with these people. And now we're back to where we live on Amelia Island. And, it's great down there, but it was almost like being in Atlanta again. A lot of traffic, a lot of cars, a lot of stuff going on. And it really felt good to get back to sort of the Mayberry RFD at the beach, which is where we are. So we had a great time. What about you, Alan? What have you been up to?
Not much. We just got back from vacation on Saturday. So we got back last Saturday, I guess it was. And so we're just kind of getting caught up. So all last week. I was here all last week, and this was the second full week back from vacation. So
that's one of the tough things about vacation is just getting things ready to go.
I know.
And then catching up when you get back. But hey, it's all in fun, I guess.
Yep.
So I'm going to go now to share my screen. If I can find it, there it is. There it is. And you tell me, Alan, if you can see it there, the title slide.
Yes. Got it. Yep.
Viral images may still be protected by copyright. And before Alan got into the beginning of this call, I was looking at this slide and I'm thinking it's really pretty deceiving, maybe, where it seems to convey the idea that if an image is viral, it might not or probably will not be protected by copyright. And if that's the message that you get from looking at this title, it's really a little bit misleading because all images are subject to copyright. And we know, this is by way of review, that the copyright, generally speaking, vests in the photographer when that image is snapped, right? So the big question here that you need to be thinking about as we review this material is, we know that if you're typical, you probably every now and then are tempted to grab an image off of social media or maybe do a Google search on images, and you find one that you really like and would really like to use for, say, a social media post, and you look and it doesn't appear to have a copyright notice. So can you use it? Well, there's the issue of copyright infringement because you're using an image where somebody created this image, somebody photographed it, somebody pulled the clicker on the camera, and that person is the copyright owner, as we've covered in past Hangouts. So you've got to figure out a way, if you're going to use the image, to maybe look at fair use of that photograph, even though it is copyrighted and owned by someone else. Do you have rights under the fair use doctrine to use it? And that's what we are going to be talking about here in this presentation. That's what it's all about. So let's get moving here. You've seen this housekeeping announcement many times. The presentation is for informational purposes only. It's not legal advice, and we're not affiliated with the Federal Trade Commission. Now, this is a little bit larger image than the smaller one that we saw on the title slide. You may not be able to recognize the two parties. On the right side of the image there, the two figures that are most prominent, the right side is a young bride dancing at her wedding reception. And on the left, the guy dancing with her is none other than President Donald Trump. So it's this photograph that's really at issue here. It went viral, and I'll explain how all that happened, which later resulted in a copyright infringement lawsuit. So that's what we're going to be talking about as we drill down into fair use. So here's the background behind this photographer, or this photograph, by the photographer Jonathan Otto. It was taken at the Trump National Golf Club in New Jersey. Otto was a guest at the wedding, and apparently Donald Trump, when a large wedding party decides to use the Trump National Golf Club for the wedding reception, if he's there for whatever reason, sometimes he likes to drop in as a surprise appearance. It's not scheduled at all. and then particularly dance with the bride, have his picture taken a few times, that sort of thing. So Otto was there. He shot this picture with his smartphone. It was done for personal use. He's not a professional photographer. And he shared the photograph, as you can see in the third bullet, only with a guest. And he didn't post this on social media. The photographer who owns the copyright in the photograph did not post it on social media. Yet, the next day, as you see in yellow down there, he looks at the paper and he sees the same photograph on CNN, Washington Post, Daily Mail, and particularly Hearst Inquirer website, plus others involving news websites. So here is what you might call the chain of custody of this photograph and how it went viral. And some people think that if it's viral and it's on the internet, it's just there for the taking. It's in the public domain. Not necessarily true. Here is the way this the chain of custody might say how the photograph ended up being published. So Otto at the very top left is the photographer and the copyright owner, as we've seen. He shared the photograph with a guest who shared it with a couple of other guests. And then one of those guests posted it on their personal Instagram account. And that's where 5 news sites picked up the image. Obviously, an image of the president of the United States attracts some attention. These news sites saw it, thought it would be maybe a good human interest publication, an article here about Trump. And the heading there you see in blue, in yellow at the bottom, President Trump is the ultimate wedding crasher. And of course, these news sites did not have authorization by Otto, the copyright owner. These news sites just grabbed this picture and viewed it as viral, thought they could actually publish it. So what in the world was their legal basis? We'll get to that in just a minute. But first, let's look at what Otto did when he discovered the news sites publishing his photograph. He retained an attorney, and then he registered the copyright in the photograph with the U.S. Copyright Office. If you're going to sue someone for copyright infringement, a registration is a condition for bringing the lawsuit. So you've got to have a registration of the copyright. They probably did this on an expedited basis and then went about filing 5 copyright infringement lawsuits. They were all settled except for this Hearst version of the posting and publishing of the photograph. Hearst did not settle. And this is where we can go to school a little bit on what is happening here in this situation. Hearst basically replied with a motion for summary judgment. A summary judgment is a type of motion filed at the beginning of a lawsuit by a defendant when the defendant says there is no issue of fact. The facts are not in dispute, and so we can go to the court and have the court rule as a matter of law on facts that are not in dispute. And of course, they're saying that that they're relying on the defense of fair use. And you see the description there of fair use. Essentially, fair use is a defense to copyright infringement. A defense to copyright infringement. So there's infringement, but now we have this defense known as fair use. And I'm going to read this very carefully, quickly, because it's important. It's a doctrine that brief excerpts of copyrighted material may, under certain circumstances, be quoted verbatim. And listen to this, for purposes such as criticism, and you see highlighted news reporting, because that's essentially what happened here, teaching and research, without the need for permission from or payment to the copyright holder. So the purposes are criticism, news reporting, teaching, and research. Those purposes, along with some other factors that we're going to talk about in just a minute, the 4-factor test, will determine whether the fair use defense applies to the defendant here and would apply to you under circumstances where you might be thinking about grabbing an image off of a social media site to use for your own promotions. So the court is beginning its analysis now with respect to the question of fair use. And it's interesting to note very important to note, as you see from the top here, the first bullet, a lot of people are essentially incorrect in thinking that copyright is there to protect the owners of the article, the text, or in this case, it could be an artwork or a photograph. Those are copyright subjects of copyright. It's really not the case. You can see there at the two sub-bullets, the ultimate purpose of copyright law is to benefit the public, right? And so the copyright owner is a beneficiary, but the public is the intended beneficiary. So we have this fair use doctrine that is the statutory exception. So here we go on the basic comment by the court on this news reporting part of fair use, the defense. While an entity's status as a news publication may be highly probative on certain relevant inquiries, such as whether that entity has a fair use defense to copyright infringement, this is important. It does not render that entity immune from liability under intellectual property law. So let's look at the 4 factors. These are important because if you are wanting to grab a so-called viral image off of social media, you need to think about these 4 factors. And if these weigh in your factor as a potential defendant in a copyright infringement lawsuit, then you feel like, well, I've got the fair use defense on my side and I can use this copyrighted material. The only problem is you may have to go to court to prove that you actually are entitled to that defense. Nevertheless, these are the factors you need to consider, and there are 4 of them. Number 1, the purpose and character.
Hey, Chip.
Yes.
Chip, nobody can see the underneath court comments and news reporting. Nobody can see any words there. It's all blurred out. All we see is 2 lines.
Are you looking at this factor number 1 slide?
No, it says court comments and on news reporting.
All right, I've just backed up 1 slide, and that's the one that I just read from, right?
No, that's not what we see. All we see on the screen is court comments on news reporting.
All right, well, I can see that what I just read, so I have no explanation of why that can't be seen. So I'm going to advance the slide.
Yep. Now we see factor 1.
All right. So you just need. I'm going back one more time.
Yep.
Do you see it now?
Yep. See it big now.
So I don't understand why it was not visible before, but this is just a general statement that the court made that to the effect that, you know, there is a fair use defense based on news reporting, but that doesn't mean if you're in the news business that you're just immune from liability. You have to go through these 4 factors. That's the essence of what that is all about. So factor number 1, what is the purpose and character of the use? And this one is extremely important because if the use that you make to what you think is this viral image is transformative, that is a huge factor in your favor for the fair use defense. And that's one of the most important ones among the 4. Is the use transformative? So one question is here, because we're dealing with a news outlet, was the publication news? Yes, it was. It was factual. But the purpose and character is reflected by the fact that the story was little more than a description of the location of the event. There was nothing there, as you see in bullet number 3, where Hearst could have added new information, new aesthetics, new insights, and new understandings. It just said, you know, here's the photograph. Trump dropped in, danced with the bride. Everybody had a good time, and he left. But there was no commentary. There's no transformative use of that photograph, just the fact that it was there and he attended it as a surprise. In order for the use to be transformative, again, very important, something really new insights, understandings, new aesthetics, new information has to be provided. That didn't happen. Therefore, factor number 1 weighs in favor of Otto, the copyright owner, because it's not transformative. Very important. Number 2, the nature of the copyrighted work. And that really means, was the photograph expressive or creative, right? if it's creative, if you look at bullet number 3, if this photograph was creative, it would have had to involve some sort of control over the subject matter by the photographer Otto. But you see in bullet number 3, Otto didn't pose the subjects. He didn't control the lighting. He didn't control where they were in the room. He didn't control whether they faced the camera or each other. He just simply pulled out his phone and snapped this thing. So if he had done these things the way a professional photographer would, chosen the exact place in the room, the lighting, had them look at each other or look at the camera, smile 1, 2, 3, then you could argue that it was creative, but it was really not. Because it's only expressive and not creative, that factor weighed in favor of Hearst. So now it's 1 versus 1. We move to factor number 3, the amount of the copyrighted work that was used. And it's pretty simple here. The answer is yes, the entire photograph was used. And you see in the second bullet, you can use the whole thing in certain cases if it's transformative, but it wasn't transformative. Therefore, since it's not transformative, it favors Otto. So now we have, at the end of the third factor, 2 in favor of Otto and 1 in favor of the defendant. So the defendant has got to win number 4 to create a stalemate or lose this darn thing, right? When we apply these 4 factors. And factor number 4, the effective of the use of the on the potential market for or the value of the copyrighted work, the photograph. Was there a market value for the photograph? Yes. If there was no market value, then this factor really doesn't apply. And as soon as Otto, as you see in the second bullet, as soon as he realized that the photograph had value, he wanted to realize the value, but it was already used. And so he needed to go take some steps. So this one actually, factor number 4, actually favors Otto. So when we weigh all of these factors, there are 3 in favor of Otto, the photographer and the copyright owner, and only 1 in favor of the defendant, Hearst. So now we see the ruling on the motion. The judge found that.
Chip, we still see screen factor 3.
Okay, well, you need to understand, I don't know how to change it. I mean, I can go back to factor 3.
It's on factor 3.
Okay, but I was at two slides beyond this. So I don't know why we're not picking the movement up. So I'm moving to factor 4 now. Do you see that?
Nope, we're not seeing, nobody's seeing it move.
Okay, I'm not sure I can do anything. I'm going back to factor 3. I did this before when you indicated you weren't seeing what I was seeing, and it actually worked. But so when I switch from 3 to 4 now, can you see that?
I just still see factor 3.
All right. Well, hopefully the replay video is going to pick this up. If it doesn't, I'll just have to shoot the darn thing and get it up there so people
it just now moved over to factor 4.
So there's about a 15-second lag here. So as we said just a minute ago, or a couple of minutes ago, factor 4 weighs in favor of Otto, the photographer and the copyright owner, because there was a market value and for the work, and as indicated by the fact that it was published widely. And Otto took steps to do the best he could, given the circumstances, to realize as much value as he could. Now I'm on the slide that says ruling on the motion.
Yep.
You can see it, right?
Yep.
So here we summarize what Judge Woods found regarding the weighing of these 4 factors. And as I've indicated, 3 of the 4 are in favor of Otto, the photographer, copyright owner, only 1 in favor of Hearst, the defendant. So at this point, the ruling on the motion filed by the defendant Hearst is denied. And this is a quote by the court. Stealing, that's a terrible word, stealing a copyrighted photograph to illustrate a news article without adding new understanding or meaning to the work does not transform its purpose, regardless of whether the photograph was created for commercial or personal use. So you remember at the very beginning, I talked about how important it was to create a transformative use of this copyrighted work. And here you see it as very important in this very important sentence, which I think captures the essence of this ruling by the judge in this case after weighing the four factors. You've got to add new understanding, new meaning in order to transform the purpose of the work. Without that, you're not going to be able to prevail on a fair use defense. So now we move to the takeaways. Can you see the takeaways screen?
Yes.
So the first one here is really sort of obvious. Hearst should have known better. I mean, Hearst is a professional news organization, a professional media outlet. And, they should have known better about fair use. But I think the mistake they made is that they felt that they were a news organization, and that's all they needed in order to take advantage of a fair use defense. They didn't really think about these factors and try to make some transformative use of taking this image. They just felt like, well, we're a news organization, we should be able to prevail on a fair use defense, and went with it. They should have known better. That's essentially bullet number one. And number two, it's important that, and this is where I get questions all the time. Well, the picture was went viral. It was on social media, or I did a Google search and there wasn't a copyright notice on it, and I should have been able to use it because it should have been clear that it was in the public domain. No, I'll read that bullet number two. The fact that a photo is posted on social media has gone viral and is an amateurish effort, which of course is what this was. This guy just snapped it on the fly with his cell phone. Does not mean that using the photograph without permission is risk-free. So even this photograph taken by an amateur without posing anybody, it is definitely copyrightable. And the four-factor test apply if someone wants to use it and claim the fair use defense. And ultimately, you see in bullet 4, be very careful with the fair use defense of copyrighted material. Now, this presentation is not the first time we've talked about fair use defense. It's obviously very important because the use of user-generated content, viral images is really important, and you need to understand how you can use those images and avoid a copyright infringement case. So if you do a search in the member area, search for image rights, also search for fair use. I believe there are at least 2 prior Hangouts that we've had in the last year and a half or 2 years that talk about these same issues in a slightly different way. So if you're interested in the fair use defense and in copyright protection of photographs and images, search for image rights and fair use. So we conclude with the tags, pretty simple and obvious, I think, for me to post tomorrow morning with this replay video: copyright infringement, fair use, and image rights. So I'm going to kill, if I can get around here, kill the screen share and get back to answering questions or any discussion that Alan want to make. And again, I apologize for the difficulty in displaying some of the slides. I've never had that happen, but it's really the first time since we've been doing it. I have no explanation for it, but sometimes
technology happens.
Work as we intend.
Yep.
Hopefully we backed up a few times and we picked those up. Hopefully we didn't really miss anything after we backed up. So are there any questions at this point?
Yeah. Let me see. Somebody put in here, Shelley, what does transformative mean?
Well, I mean, think about the word transformative. It definitely means change of some kind. And so I sort of figured somebody would ask this question. And I was thinking of a great example of how this particular photograph could be transformative, right? What could Hearst have done to create make a transformative use? And I'm not sure. It would be pretty difficult to do. There's a picture in this country club of Trump dancing with a young bride. What can you say to sort of make it different, to create some teachable moment out of it? Maybe you could write a story about how important it is for a politician to be spontaneous, right? And approach it that way with some angle about how clever you think Trump might have been by choosing this moment to come out in front of voters and present himself in a very, I'm just making this up, okay? Spontaneous way, and and say it's a really smart move or it's not a smart move for a politician to do. At least comment about it one way or the other, as some sort of an opinion on whether it was a good idea for a politician to do. That's about the best I can do. And maybe if you'd taken one of these opinion routes and developed it a little bit in the story, that could have arguably been transformative. But as you can remember from one of the slides, it's just that he's the wedding crasher in a sort of joke, the wedding crasher in chief or something like that. That wasn't enough. They had to go and create some opinion about it, or maybe change the photograph in some way with a border around it, maybe a diagram, some sort of image around it.
Yep.
Wedding crasher question. That might, do a little heart or something around it. The ultimate wedding crasher. Add some artwork to it on the side, something like that, maybe. But that's
how about turning it into a meme?
Great examples, but it's about the best I could come up with. But that's the idea. Something to add to it to provide an opinion or some commentary that would change just posting the picture.
Yep.
All right.
Something apart from copyright consideration. What about the use of photos without getting publicity releases from all the parties? Photographs.
That's an interesting question. The right of publicity and the right of privacy. We've talked about copyright. So really there are three. And I believe, I'm not sure, because I actually went to the member area and I did the search on these two tags, and image rights and copyright and fair use. And they all were sort of dealing with different versions, different fact patterns of this same idea. We do have a lot of material on rights of publicity and rights of privacy. So if you're interested in that angle of this, search on right of publicity, right of privacy, and you'll see additional past Hangouts on those two things. So when you're talking about using an image, you need to think about three things, actually. Number one, of course, is copyright, because some photographer took every one of those darn things, right? So there is a photographer out there who owns the copyright. And then are you using the image of a famous person? Is there a right of privacy and publicity? We talk about that in these prior Hangouts. So those are issues as well. Not presented in this particular fact pattern, but generally related to use of photographs. So, we have plenty of coverage on that in prior Hangouts. All right.
This is from Sue, and it's more a question of looking for ideas, and other people are kind of popping here trying to ask. She works with gymnasts, and she really can't use any of the gymnast photos without the parents' permission and for the children and stuff like that. And she's looking for ways to post pictures. I can't use images of of competitions because they already are copywritten by the photograph. Any ideas of where what to do to get?
Well,
Tom said, Tom said subscribe to a service, which I subscribe to two different services. So
when you're talking about images, is that what
Photo Depot and one other I'm a subscriber of.
dreamstime.com.
Yeah.
And I get a lot of the images you see in my presentations are taken from Dreams Time. So one route is to subscribe to an image service, to pay a very small fee. You get a license to use it. Um, um, the other one is Creative Commons. That is a way to use certain images generally speaking, by giving credit to the copyright owner. We have I know at least one Hangout devoted to Creative Commons. That's another option in addition to going to an image service where you have to pay a small price. Um, the the conservative way to do it is through what is called a model release, right? And we've got one in the member area. And Alan's been involved in attending marketer events a lot longer than I have. But as the years roll by, I've attended a few myself. And I remember back in 2011, 2012, I would go to an event where people were snapping pictures to use on social media to show people in the audience and all of that. And nobody had asked me to sign a release for my image. Nobody thought about it. And I don't know whether they heard me talking about it or whether somebody finally said, look, you guys, you need to get clearance. And so all of a sudden, when we started going to events, when we checked in to the event, we had to sign something similar to the model release form that you'll see in our generator. Yeah. So now it's fairly common. A few years ago, it wasn't common at all. Now everybody does it. So the model release is the tried and true. Let me give you one other example, and I don't know if this would apply to you, but it was very clever. I'm a certified barbecue judge, right? I don't judge as much as I used to, but I was at the biggest event in the state of Georgia called the Big Pig Jig about 6 or 7 years ago. And before the big event started on Saturday, they had a late Friday evening meeting for the judges. And this was when a film crew was there to film 3 or 4 TV guys who were competing. And they were going to use it on a TV program, which they later did. And so this guy calls everybody in, and they had a big spotlight on about 50 judges gathered around this little platform. He's up there with a microphone, and he has a videographer standing beside him with the big video camera. And he says, look, some of you, not all of you, but a few of you are going to be judging these celebrity guys who are who are going to be on TV in about 6 months. We're here filming a segment for this show. And so we need to get your permission to use maybe your name, but certainly your likeness, which is the photograph. But we don't have the forms with us. So what we're going to do is we're going to announce, and we're videoing this. All of you who want to give us permission, you raise your hand and stay where you are. And if any of you do not want to give permission, walk away. And a few people scurried away, and I'm thinking, why would they not want to be identified here? I didn't get into why, but there was something going on there. I'm not quite sure. So the 4 or 5 people left, 45 or 50 stayed, and the videographer went around with the light, and he moved around, and he got everybody there. And so he said, now, just one more time, everybody here is in agreement that I can use your picture in the video if you're videoed with this crowd. And everybody said yes. And so they viewed that video with the yes and, the opportunity to leave as permission. Now, I think it probably would work. I'm just not sure that it can be applied to precisely what you're doing, but it might be. There's an option for you.
Yeah. So I would look into it if you're the one, putting on the competitions, like putting the event on. I would make it a habit of having everybody sign these days. We do when we go to events, we always sign that. I did when I used to put on triathlons way back in the day. We had everybody sign because, of course, we took pictures and video of all the triathletes going down the road and everything else. And they went to media outlets. They went everywhere. So I had to have everybody sign stuff in case we caught somebody and it got on TV or whatever.
Yeah. So if it's your event, you're sponsoring it, you're in control.
Yeah.
You can catch them at the sign up registration desk, and they'll just about sign anything if they're interested in attending, right? The problem is if you're not the sponsor, if you're not in control, it's going to be much more difficult to have people sign releases for you.
Yeah. And we have another one here from Shelly. And I'll say into the start, Shelly, I think this is like borderline, just kind of like gray line. You're kind of cutting hairs here. It says, I've seen where there's issues when cropping or changing a photo that was actually purchased or used. Does changing the filter or the lighting of the image means that it's transformed?
It's hard to say. I mean, this is a question of, you've really got
That's
to
right.
see.
To me, that's kind of like trying to split hairs. Yeah, it's trying to split.
There's no way we can say, yeah, crop it and you're fine. That won't work, but it might be persuasive in certain situations.
Yeah.
If you're licensing a photograph, it's possible there could be some restrictions that say you can't start changing it, but I don't know. But anyway, we can't say yes or no. It might be persuasive if you're making other changes, and this is just one of several changes, but we can't say yay or nay on it for sure.
Okay, so I want to start with we're wrapping up here. So everybody knows June next month, the Hangouts are going to be on June the 11th and June the 25th. If you want to mark your calendar, put it on there. So the 11th will be at 7 p.m. Eastern time, and June 25th will be at 8 p.m. And Chip, you want to just give them the topics real quick? They're very similar topics.
Yeah, there are two very, and I'm looking over here at my notes. There are two very interesting cases that are very recent. And one of the legal services that I subscribe to, there's been a lot of articles written about these two cases. And the reason I think is that the lawyers who wrote these articles know that there's a lot of interest in these two fields among online marketers. And I think I agree. The first one is a case involving a company known as Earthbox, Urthbox. They were involved in deceptive reviews. They incentivized reviews. And we've had some discussion in past Hangouts about doing that. Meaning that if you incentivize the reviews, they're not completely objective. They might have been influenced by the incentive, right? So we're going to talk about that. And it's a really big, a lot of people have been commenting on this case. So I chose it for that reason. And then the second of the two in June is a case called Devumi, Devumi, and it involves something similar. Deceptive likes and followers, right? Deceptive likes and followers on social media. Another important thing that, sometimes you can actually find services online that if you pay them, they'll just give you a bunch of likes, right? Yeah. And so that case talks about that issue, deceptive likes and such. So we've got two topics that are very much tailored to online marketers. And two cases that are really talked about a lot today among the legal community. So that's what we're going to be following up with for June.
Okay. That's it.
Is that it?
That is it.
So thanks for joining us, and we look forward to seeing you in June with these two Hangouts. Good night, everybody.
Good night.